What is the bazillion paragraphs worth of boilerplate language in your new employment contract? Time, geography, scope of activity, what the frick is this? It's a non-compete. Stay tuned as we unpack what's a non-compete, what's enforceable, and what's not, because guess what? A lot of them aren't. Welcome back to #Lawyered, everyone. You have your favorite legal A team, Austin and Andrea, back live and in studio, or I guess like in your podcast situation.
Today, it somewhat, said this right before we came on air, can be a dry subject, but it's highly applicable to a lot of people's lives, and especially people making career changes, making changes laterally to other jobs. And there's a lot of myths that are surrounding this area of non-competes.
So many myths. And I think a lot of people have the feeling like, oh my gosh, I signed this agreement and I'm in Texas, and I know in Texas courts love to uphold contracts, which they do. They love to uphold I'm banking on that actually in the case I was telling you about in the pre-show. So, but anyway, non-competes. You see a lot of these.
I do. And I think on the opposite end of the spectrum, I hear people say all the time, well, Texas is a at will to work state, so non-competes aren't enforceable. Like,
false.
No, that sounds pretty, but that's not how that works either.
Yeah, you can have a valid non-compete in an at-will state.
Right, absolutely. And as you and I were talking about, and as we're going to get into, you can have them, they can be enforceable, but there's just, in my opinion, the employee has the advantage in this arena legally.
Yeah.
There's some other factors we'll talk about that go into it as well. Primarily, how much money do you have to spend on all this?
I think that's the biggest factor.
Yeah.
I think I'd actually have to disagree with you on the employee having the advantage. I think whoever has the advantage, it teeters between how clear the case is and how much money the company is willing to spend.
Yeah. Well, and let's talk about the money side right now, because we can get into the legal stuff here in a second.
Sure.
I mean, when you say that, what do you mean by that about who has the most money to spend?
Sure, right? So we were just talking about earlier how non-competes are very, very expensive. And so at the end of the day, and this is true, I think, for most like legal cases, family, civil, I don't know about criminal, you can talk about that. But at the end of the day, the winner often is whoever has the most money to spend and just outspend the other party. Because if you take the other party and you bring them to motions for summary judgment, you bring them to injunction hearings, you demand tons of discovery from them. Well, at some point, if you just don't have the money to keep up, you're just going to be sick of it and you just want to be done. And you're like, I'm going to go broke defending myself or prosecuting this case. So we just need to settle. Yeah.
Yeah. And in the area of non-competes, it's a highly active lawsuit. It's
very active lawsuit.
You got a typical breach of contract case. Someone files the lawsuit. You do the discovery like you were talking about. And eventually you may end up in trial. There's some other things like summary judgment you can do. But in a non-compete, usually you end up with a temporary restraining order hearing. You end up with a
right off the bat,
temporary injunction hearing.
Which is like a mini trial.
Right.
Most people don't know that. So it's like evidence, witnesses, everything.
Right. I mean, you're talking about realistically and reasonably spending $15,000 to $25,000 right out the gate.
Oh, absolutely.
Defending yourself if you're an employee trying to move jobs. And so that's where that leverage really plays in, where you could have a big Fortune 500 company that has the ammunition to be able to support that kind of a war. Yeah. And you as the $60,000 a year employee, I mean, you're talking about almost half your salary to pay for
think about it. Like if you worked for Coca-Cola, right? And you were a chemist formulating a vanilla Coke Zero. Does that even exist?
I think it does.
Okay.
Not a Coke guy. So.
I don't. You just defend people.
Exactly. So I'm glad you picked up on that one. Good.
It took me a moment. I've only had one cup of coffee. Anyway, so if you were creating this new cherry vanilla Coke Zero flavor, if you will, right? And you were one of the engineers in that, which apparently it gets real sciencey. My friends and I were talking about this the other day. But if you leave and you have the know-how and you go to Pepsi, and Pepsi is trying to launch something similar, you can bet your bottom dollar that Coca-Cola is going to go nuts.
Yeah.
Nuts trying to prevent them from going to Pepsi and divulging trade secrets, which they shouldn't be doing anyway.
Right.
But, once you have the know-how, kind of hard to prevent people from using it.
And Coke's going to spend the money to have the fight and all of those things.
They're going to spend a lot of money because they have a lot of money to spend.
Yeah.
And I'm sure chemists make good money, but not as much as a multi-zillion-dollar empire that is Coca-Cola.
Yeah, exactly. So, well, let's get into it and talk about the actual specifics of a non-compete. Because I think people also just say the phrase a lot and they don't fully understand what it actually entails.
Yeah, so let's just go ahead and then break it down. So basically a non-compete, right? It's the portion of your employment agreement that says you are restricted from going and working at an entity that can compete with you in this particular industry for X amount of time in X location, and it defines like these specific activities you can't do, which makes no sense when you explain it like that. So let's give an example, right?
Yeah.
What's a good example besides my Coca-Cola example? Because I'm very proud of that one.
Well, and I'll just draw from cases that, I've worked on before, but the idea is, you work in a company that, let's say deals with medical devices.
Sure.
So you're a sales rep for a medical device company. You work in North Texas. You've got clients that are in Plano, Dallas, Allen, Frisco, all around. And in your employment agreement, it says you cannot go work for a competing business. We'll talk about that term here in a little bit.
It's a term of art, really.
Right. You cannot go work for a competing business within, let's say, the DFW Metroplex. Let's just say they use that term.
Sure.
For 2 years after your employment with this company ends. And the reason they have that in there is because the company believes that you are going to learn some proprietary information. You're going to be exposed to the company's trade secrets, and they don't want you taking that and using it at a competing company basically as a competitive advantage against your former employer.
And damaging the former employer's sales.
Right.
It all comes down to money.
Right.
That's all they care about.
Which is another part that a lot of people don't think about. Just because someone goes and competes somewhere else, there's got to be an actual loss in sales. There's got to be an actual damage for there to be money on the end. I mean, the injunctive relief and the TRO stuff, that's a little different.
That's a little different, and we can talk a little bit about that later, because I think it's really important for people to realize when they say, I want a restraining order, I want an injunction, I'm like, okay, but you're going to have to pay a lot of money up front. Like, expect to pay at least $20,000.
Right.
And I say that for a fairly non-complicated injunctive relief situation.
That's reasonably priced at an attorney hourly rate.
Yes, exactly. So, no, but that's a really good example, right? And so like almost any civil lawsuit, right, with the exception of like trespass, you have to be able to show damages. Right. And non-competes are no different. So, but all right, so at the end of the day, that's what a non-compete is. But how do you make a non-compete enforceable, right? Because we just said earlier, not all non-competes are enforceable. And in fact, a lot of them aren't.
Right.
So, and I'm just going to read straight. I know, guys, this is so boring, this part right here, but it's really important to understand.
Yep.
So I'm just going to read from the Texas Business and Commerce Code, section 15.50A, because that's where we find our
rule. So the authority comes from.
So always read the rules, guys. So anyway, non-competes in Texas are technically called covenants not to compete, right?
Right.
Okay. So a covenant not to compete is enforceable if it is, one, ancillary to or part of an otherwise enforceable agreement at the time the agreement is made, and two, contains limitations as to time, geographical area, and scope of activity to be restrained that are reasonable and do not impose a greater restraint than is necessary to protect the goodwill or other business interest of the promisee, aka employer. Okay, so that sounds like a bunch of legal gibberish.
And it is.
It is. It took me a lot of research when I first got a non-compete case to really break it down and understand what.
Yeah, and that's, for me, I always tell when I'm talking to clients that come into my office or explain this to anybody, I always tell them, look, there's four components to it. One, and we're about to break all these down. One is it's ancillary to another agreement. It's got to be an additional agreement within the agreement. Yeah,
it has to be part of the agreement. The non-compete, you can't just say, hi, Coca-Cola, I'm going to work for you. And Coca-Cola can't be, oh, here's a non-compete. And that's it.
Yeah.
The non-compete has to be a portion within an otherwise enforceable employment agreement. It can't exist on its own. It's like a parasite.
That's a good way to put it. And actually, a lot of people think of non-competes as parasitic. So,
well, they kind of are.
so let's jump into the ancillary to an otherwise enforceable agreement, because that's something. That's the part we talked about this before the show.
Yeah.
I think 90% of the non-competes I read, I believe, are unenforceable. The way they're written, and I think this is the biggest prong that the people who write these, the people being the lawyers who write these, miss, because they don't do it the right way, or the company doesn't carry out the agreement the right way.
It's one of the most confusing elements.
It is.
In a non-compete situation. So we'll try to break this down, because this gets a little long confusing, this part, right?
Well, I think that just to start, I think that the point you just made is that you don't, a non-compete is not enforceable just because you're employed by a company.
Exactly. You have to have more than just the employment.
Yeah. And I think that's kind of the starting point that people got to get out of their minds. Just because you work for a company doesn't mean they can enforce a non-compete on you. There's got to be this extra part, which we're going to dive into.
Yes, absolutely. So, and I'm going to try my best not to get too legalese here, but basically, when you have your employment agreement, like you said, it has to be more than just the non-compete. So it's someone saying, I'm going to hire you, right? And you're going to agree to not compete with me. And then they give their restrictions. But in return, right, the person is being given access to proprietary information, say a super specific way to gold plate jewelry so that you can mass produce cheap jewelry that actually looks super expensive and you can swim and tan in it and it won't rust like a piece of junk.
It's a great example.
I mean, I would buy that off Amazon. I'm not trying to go broke over here. So now they've got this proprietary information, and maybe this company it's been a Instagram darling Kickstarter. And so everyone knows the brand. People are really into this brand. And then when this person is brought on, they are part of the Instagram marketing and influencing. So their face is now associated with this brand.
Right.
And so they're kind of tied into the goodwill. And if they ever left the company, that goodwill would be damaged if they went and worked for basically the exact same company, just under a different name. Right. And then they're given access to client lists.
Yep.
And then they interface with these clients, and they go to different socially distanced fundraising events to get more capital for R&D into, I don't know,
silver-plated jewelry.
No,
platinum's better. Better.
Silver, come on. Platinum.
Yeah.
And so now we have all these things that are in addition to the non-compete, right?
Well, because you can break that down, right? First, and that's the whole idea of the ancillary, right?
Yes.
So look, first off, she's saying, okay, I'm going to work for you. In exchange for working for you, you're going to pay me.
Yeah.
Okay, well, that's the employment agreement. You got to go separate from that, like you were just talking about.
There has to be more than just payment. Right.
And that's what it is that, okay, what are the things that the company was giving her? One, access to our proprietary information. And we're saying we're not going to give you that access unless you agree to this non-compete. Access to use our brand and to market our brand. Access to our customer list. And so in exchange for that access, you're going to sign a non-compete. And some people ask, well, okay, well, what if I don't want to sign the non-compete?
Okay, well.
I'm not going to work there.
Yeah, probably not.
Yeah, I mean, and that's fine.
I mean, who's really that valuable?
It's rare, in my opinion.
I mean, maybe Kylie Jenner, but...
Maybe.
But what brand is she hawking besides her own? I mean, the girl's like a billionaire, right?
I think so.
Yeah, Forbes, something or other.
Yeah, but yeah, I mean, it's. We're saying that these are weak and they're hard to enforce, but you got to at least get past that point. At least if they've made an effort to say, okay, well, we're going to give you this set of confidential information in exchange for the non-compete. Now, and here's something a little more nuanced: is a lot of the fights that I've seen start is something actually confidential? Is it actually proprietary?
Yes. And that is something I think, because I've done a lot of business litigation with theft of trade secrets and misappropriation. And so that actually gets really interesting because what people think is worthy of protection is not always what actually is worthy of protection in the eyes of Texas law. Yeah,
absolutely. Well, and I think that, and I know you've seen this probably plenty of times, is people will slap this non-compete down and list off confidential information, and there'll be like 37 things listed in there. So you can't just claim every single thing.
No, you can't claim everything is confidential. You can't claim your email address is confidential.
Right.
You know, that's ridiculous.
The type of coffee creamer you use in the break room, all those types of things. But I've seen some pretty ostentatious stuff that's been thrown in to those confidential information. And the court's going to look at that and say, that's not confidential.
Yeah.
You don't even do this type of work, or this is not even proprietary to your business. And so if the court finds it's not confidential, well, then you can knock this first prong out.
And especially too, maybe the company does have confidential information, right? So let's take our example with the gold plating jewelry company. Maybe this person is hired, but they're not exposed. Take away the fact that they're exposed to the proprietary information. They're just hawking the jewelry on Instagram, right? They're just an Insta model. Okay, now if they come in and slap the non-compete in front of her and say, you had access to our confidential information, and because of that, there's more than just an employment agreement. You promised that you wouldn't divulge our confidential information. We're going to sue you for violation of your non-compete and for distribution of confidential proprietary information. She doesn't know anything.
Right.
She's just like, you gave me the jewelry to post pictures of on Instagram, which can be hard. Like, look, getting the right lighting is hard, but she doesn't know the science behind it.
Sure.
So she doesn't have that proprietary information. So just because it's in her employment agreement doesn't mean it actually applies.
Exactly. So I've seen this play out in other companies before where certain database access is restricted. Some employees have access to this database and not this one. And if they don't have access to the higher level confidential databases or company information, well, you didn't give them the information. Just because you said in the employment agreement, you have to actually give it to them.
You have to actually follow through, and you have to actually perform under the contract, just like any other contract.
Yep, exactly.
Right? Lack of performance renders the contract meaningless a lot of the time.
Yep.
So yeah. And so, I just also want to backtrack and explain that there has to actually be something worthy of protection, right? So you can't just put in a bunch of fluff into an employment agreement in order to try and say that, oh, look, there's other stuff in this employment agreement. So it's not just a non-compete. There's other stuff in there too. Like, for example, if you are a anesthesiology assistant, right, at Children's here in Dallas. Okay, so you sign up, you have a non-compete. It's kind of weak, and basically the non-compete is if you go work anywhere else in the next 2 years in the DFW Metroplex in the field of anesthesiology, you're going to be harming the goodwill of Children's. Okay, well, that's not going to really be enforceable because what goodwill is there? Right. Your skill and training as an anesthesiology assistant is going to be the same no matter if you're working at Children's, Baylor Scott and White, UT Southwestern. I don't think that would be a enforceable non-compete. Yeah,
well, because a big part of the analysis is exactly what you just said. If someone's coming into a job with a certain amount of training, education, and experience, well, they didn't learn that on the job.
Yeah.
And you didn't give them anything extra. Maybe you trained them on how to do certain processes the way you like them done at Children's. Maybe there's something enforceable there. Maybe. But that experience is going to really fall in the favor of the employee who's trying to leave, because you can't keep them from using what they already knew when they came into the job.
Absolutely. And the goodwill, how is the goodwill affected?
Right.
And so I think they would fail this first prong of a non-compete analysis.
Yeah, absolutely.
But speaking of first prong, there are a lot more prongs. There's a second prong, and it's actually divided into 3 subparts.
Yep.
So, and this gets talked about a lot, right?
Yeah, and overall, I think this is like most things we talk about on this show. We break it down as black and white as we can. It's never black and white in court.
It's never black and white.
And that's why these fights get so expensive.
Absolutely, especially when they want injunctive relief. Injunction is always pricey. So, all right. So we mentioned earlier in the second prong that non-competes have to be reasonable, right?
Yes.
So they have to be reasonable in their restriction as to time, geographic area, and scope of activity to be restricted. So I think the first 2 are pretty self-explanatory, and the third one gets a little confusing.
It does.
But Austin, what's reasonable as to time in a non-compete?
Well, and there's not really a straightforward answer.
Right. It depends on the field that you're in.
It does. What I've told people when I talk to them, from what I've seen, usually a court will say a year is reasonable. If you start getting north of that, but you need to have a good reason for it.
Yeah, or case law.
Or case law. And there's all sorts of factors that come into that. And so I've seen a year be upheld. I've seen a year be reduced to 9 months. I've seen 2 years be upheld. It's really, like I said, very gray, but that's my answer on that.
Yeah, and there are some areas, I've seen some cases saying that courts in one case upheld a 5-year non-compete, which I thought was very wild. And then in other cases, I frequently will see 2 years.
Right.
So it just, again, it's very specific on the case.
Right.
And so, it depends. which is everyone's favorite lawyer answer to hate.
Right.
It depends.
Right.
But the second prong, right, is geographical areas. You can't restrict just all of the United States.
Right.
You know, it has to be specific and relevant. So you can't say, so for example, our jewelry girl, she is living and working, and there's a storefront in Dallas, right? So on Knox Henderson, great area. So in her non-compete, it says that she can't sell jewelry in any way, shape, or form for 2 years anywhere in the Southwest. Okay, well.
Yeah.
Well.
That's going to be unreasonable.
That's very unreasonable.
You mentioned this a second ago. Time in the scope clearly, but geographic, it has to be tied to what you were doing for the company.
Absolutely.
So typically, if you had a certain sales territory, if you worked at a certain store and there's a radius, I've actually seen a lot of hair salons that have non-competes.
Oh, really? You do hair salon litigation?
Litigation advising. I don't say advising, but first off, I don't think that you're learning anything proprietary at that salon, unless it's a very specialized hair extension kind of a thing or something like that. I still think you're pushing it, but just for the geographic portion, it makes sense to maybe say, okay, within 15 miles of the hair salon, because you can't restrict all of Dallas because you got hair salons every couple corners.
Oh, they're everywhere.
But okay, maybe 15 miles, maybe there's a location advantage to it. I've seen that with car dealerships because they get a lot of business from in and around their shop location. So it's got to be catered and tailored to the specific work you're doing and where you worked. Otherwise, it's unreasonable.
Absolutely, yeah. I know I've seen a lot of cases using the phrase that the location, specifically like the county, maybe if it was like a sales territory situation, the county's contiguous to the county in which the employee was operating in and conducting work for the employer.
Right. And that's a pretty good rule of thumb.
Yeah. So if your employment agreement says all of the Southwest, you can't sell jewelry, it's probably unenforceable.
Well, and I've been involved in a conversation before where an employer was saying, well, look, we sell products online. So yeah, of course, the whole country. Like, all right, man, you're selling air filters for cars. I'm making this up.
Yeah.
But this is, I understand that you're upset, but that's not reasonable.
That's not going to fly in court.
Yeah.
Yeah. So, all right, the third one, and this one is probably the second most confusing thing out of all elements of the non-compete, is the scope of activity to be restricted.
Yeah, and the idea is you perform certain jobs at your company, right? And so that's kind of what I would say your scope of employment with that company. I mean, that's what we mean by scope, right?
Yeah, the activities that you're doing for the country. What is your job description? Are you doing the Instagram marketing? Are you actually conducting the science and the research and the R&D to create the gold and platinum plating technology? Are you just doing accounting? Like, what are you doing? What is your job description? What are your actual daily tasks and duties? That is what's going to be restrained.
And that kind of ties back into whether you're going to be exposed to confidential information or not.
It does.
Right.
And so, and I've seen this a lot too, is that a lot of times I feel employers will just use a blank, like a form, not a blank, but a form non-compete for all their employees, which is a terrible idea because then they're not specifically restricting and tailoring the non-compete to make it specific as to the activities that they want to restrict and to ensure that those activities that they're listing as restricting in the non-compete are actually things the employee is doing.
Right.
So one of the things that I think is really important is that the Texas Supreme Court has upheld that any ban that creates an industry-wide ban on participating in that industry is unenforceable. So, for example, if I am working in car sales, that's not me. We're selling hair tools,
Okay,
right? That's much better, even though I need a stylist. If anyone knows a stylist that wants to come do my hair on this show, please send them. I need help.
We're in the market for makeup and hair for the show, right?
Right. Especially for hair, I need help. So, book a birdie. No, I'm kidding. But they are great. Not sponsored. And so say I'm in the market to sell these fancy blow dryers and curling irons and a special volumizing straightener. I would like to have that, actually. That would be really helpful. And so I'm selling these and I sell them within the DFW Metroplex. And then if I want to leave, say I'm moving from Dallas up to Collin County, right? And so I want to still stay in the industry, but now maybe instead of selling hair tools, I decide I want to make the jump and I want to get sciencey and I want to help formulate and sell product to create volume in hair for fine hair. I want voluminous, fine hair that's not greasy.
Okay.
Because that's actually something that's hard to find. So if I go ahead and do that and then my employer, gets their panties in a bunch and they say, oh my gosh, you're breaching your non-compete. I know you moved up to Collin County, but that's still the Metroplex area. Slaps that non-employment agreement down, says you can't do anything in the hair industry.
Yeah.
Nothing. And if you do anything in the hair industry, I'm going to sue you. So you better go sell cars or something.
Right.
That's, Austin, what is your take on that?
Well, that is an industry-wide ban, like you were saying. And it makes sense that the Supreme Court would say that because, one, it's lazy lawyering.
It is lazy lawyering.
Yeah, if you're just going to say hair industry, whatever. And that kind of goes back to, you talked about these employers using a template because they don't want to pay the lawyers to go in and...
Right, the employer's being cheap.
Right. But back to the industry-wide ban, if you're out there now trying to formulate some type of hair product, shampoo or some kind of leave-in conditioner or something like that helps voluminize.
Or like a mousse.
Yeah. Okay. That helps voluminize the hair, like you said. That's not the same thing as selling an apparatus that you're using to do the same thing.
Yeah, it's not the same thing as a straightener.
Totally different. And that's why it gets really nuanced when you're trying to argue this stuff in court, because you got to be able to sit there and explain to the judge, who's not a industry expert, explain to the judge.
The judge who may or may not have ever seen a blow dryer in his life.
It could be a bald-headed man up there who's not going to have any idea what you're talking about.
You should pray for a female judge in this situation, or a judge with daughters.
Right. No, there you go. But that's the thing, is you got to be able to get up there and explain, well, here's the difference and here's why this is too broad. And the employer's their lawyer has to justify, well, because she worked in this industry, she's going to have an advantage. It's going to take away from our profits because of the things that she knows. And so it makes sense that they've got to narrow that down. And I think that's one of the common themes that in the scope, time, and geography, it's got to be narrowly tailored. That's a phrase that I think we hear a lot in case law, is that it's got to be narrowly tailored to the actual tasks that were learned and the confidential information that the employee was exposed to when they worked at that previous company.
Absolutely. So let's change this hypothetical a little with the hair tools and switching to create hair product.
Okay.
So say that, let's call her Roxanne. Roxanne is switching from DFW hair tool supply, where she sells hair tools, to creating, Roxy's Rockin' Hair product. And so, but in Roxy's Rockin' Hair product, she is also selling product to the same clients that she was selling hair tools to. Now, that adds a little bit of a complicating factor. And maybe she's also trying to sell a special applicator to spray the volumizing product at the roots for fine hair. You look very confused.
No. I'm sitting there. I got the gears turning.
You got the gears turning. Okay, I couldn't tell. And so, because you don't have long hair. So.
That's true.
Yeah. And so, DFW Hair Tool Supply gets upset. They slap the non-compete down in front of Roxanne. They go to the judge. And the judge says, well, you're not supposed to be selling hair tools, Roxanne. And there's a chemical product. I get that chemicals are different than tools, but now this applicator that you're selling, that looks an awful lot like a tool to me. And so in this situation, if the judge looks at the non-compete and says, well, the language says anything in the hair industry, what's the judge going to do? Because that language is overly restrictive.
Yes, it is. But this is, I think I know what you're getting at. It's a good point, is that in Texas, judges can what's called reform the clause, the non-compete clause, if it's too broad, and say, well, okay, maybe that was too broad, but the spirit of the non-compete, they can reform it and say, well, you're actually doing the same thing that they are trying to protect,
Yeah.
and we're going to change the clause so that it is enforceable, and we are going to restrict certain activities.
Actually, and I'm going to follow you up on that. They're actually required to.
Yeah. Okay.
And so, because I think that's a more recent case. So they're actually required to reform the clause in the non-compete in order to make it not overly restricting, if at all possible. If it's not possible, they're just going to find it not enforceable.
Right.
But in this situation, I think what would be a likely outcome is that the judge is going to say, all right, Roxanne, I'm going to reform this portion of your non-compete to say that you can't sell hair tools in the DFW Metroplex for the next year. So you can go sell your hair product that you've created and invented. Yep. Product is different than tools. But that applicator, that I'm going to say is a tool. And I don't think you can sell that, at least to the same clients that you were interacting with and selling with before. You can sell it to other clients, but not these same ones that you were selling to as a rep for DFW hair tools.
Yeah. Yeah, and I think that last part was something I wanted to jump in on is the idea of client lists and going after clients.
Key.
And I think that, and I may be a little more aggressive on this than some people, but I do think
really?
I think employers they have in their minds that they have a false sense of protection and security over those client lists. So I think let's take the example we're talking about. Sure. And this isn't black and white, but this is just kind of some factors. Let's say that the initial company, DFW, what was it, Hair Tools?
Hair Tools.
DFW Hair Tools. Let's say they secured these clients through the SEO type of efforts they put together through some other social media advertising and some proprietary stuff they put together behind closed doors. They secured these clients. That's how Roxanne came into contact with them. Well, I think DFW has a much better argument at that point for protecting these client lists because they were procured by DFW's own proprietary coding, AdWords, all that kind of stuff.
And they're very good about, let's make this a good example, right? So say DFW Hair Tools is very good about keeping that client list under lock and key.
Yes. Good
They
point.
never share the entire list with anyone. They talk to their sales rep. So Roxanne was only ever introduced to a small portion of that client list of people that she was permitted to sell to. And she was not allowed under any circumstance to know who else was on that list. Someone else has a different part of that list and so on and so forth.
Great. That's a great addition to it because they actually made an effort to keep it confidential because that's where we see the fight go a lot too.
And that's super critical. I think so many people don't understand that is you can have a client list, right? But for example, if you're a nail salon and that client list is, your appointment notebook and anyone can look at it, well, you're not taking steps to maintain that confidential information confidential. And that's critical because if you fail to do that, now you have a lot harder time proving to the court that this actually is confidential information and it's worthy of protection.
Right.
You shot yourself in the foot.
Yeah. And I think that, going off of that example even more, where I see this a lot is when sales reps have a non-compete, but they are hired because they are relationship drivers. They are people that go out and find clients, they find customers. That's a lot harder as an employer to say, well, those client lists are proprietary because you found those clients while you worked for me.
Well, is it?
Right, exactly. And that's always my argument is that, look, you hired this person because they are a good salesman, good saleswoman. They go out there, they develop relationships, people like them. They brought relationships in. I mean, that's kind of not even, that's not even on the table. You bring relationships into the company. Yeah. Those are not protected and the employer can't keep you from those.
Yeah, like for example, if Roxanne is going to, Saturday morning tennis lessons and Thursday Pilates and Wednesday spin with all these women and she's bringing them into the business and, she's talking to them and showing them after the Pilates or spin classes, like how great her hair looks because she's able to use these really cool products. Well, now she's spending the time to create those relationships and bring them in. They were not created through a proprietary mechanism using SEO by DFW Hair Tool.
Right. And I think that's a big distinction that everybody needs to understand is that, again, not black and white, but you understand, I hope people can see that's kind of the spectrum we're dealing with here.
So, but anyway, at the very least, people need to take away, if you have a client list and you got it through your own confidential means, keep it confidential. Keep that thing under lock and key, y'all.
Yeah, absolutely. And I think, as far as some takeaways.
Yeah, top 3 takeaways. Let's go.
Top 3 takeaways. I think that one, as an employee or an employer, you need to come and talk to a lawyer about the language that's either in your non-compete or the one that you're trying to impose Why? And this is before you ever sign the employee up.
Oh, yeah,
or
absolutely.
before you ever sign your
Before
contract.
you sign the contract, definitely go to a lawyer and have that lawyer. Frankly, you're probably just going to have to draft a new one because using form non-competes is a bad idea. Unless everyone does the exact same thing in your company,
Right.
which doesn't sound reasonable.
No, I wouldn't think so. And I'll tell you, I've got certain clients of mine that are independent contractors working a lot of different, work for a lot of different companies in a certain field. They bring me their non-competes, and usually the conversation is, no, I don't think this is enforceable. And really the second part of that conversation is, could they get a temporary restraining order if they went for it, if you violated this non-compete? And I'm going for a little bit of a tangent here, but that's really a big question.
That
because
is a big question.
The thing is, whenever someone sues somebody for a non-compete, typically the employer will ask the court to issue immediately, like you mentioned, a temporary restraining order.
Which, let's explain what that is.
Which says basically you are restrained from doing this type of action, which it would basically be spelled out by the non-compete.
Yeah.
You're restrained from selling hair product tools in the DFW area.
Just hair tools, not the product.
Just the hair tools in the DFW area. And with TRO, it's for 2 weeks.
Yeah, so 14 days.
It's like boom, 14
unless
days.
it is specifically extended by a court order or by agreement of the parties.
Right.
But it automatically expires after 14 days. You have to then get your temporary injunction hearing, which then sets out an indefinite period where that restriction is in place, typically until a trial on the merits can be had.
Right. And the injunction is very similar to the TRO, except it can last longer. And so technically, the reason we talk about that TRO in that first conversation and the injunction is that a lot of times, whichever side wins that, usually
wins the case.
They're on a fast track, right?
Yeah.
I mean, because if the employee, think about it, if the employee is told, if Roxanne's, hey, for 2 weeks you can't work, then they have that injunction hearing, which, like you said, it's a full-blown mini trial.
Yeah.
And then the court says, yep, actually, TRO is valid, the non-compete is valid, you're going to be restricted from this until this case is over. She can't work. Yeah. So all of a sudden now, we're probably in settlement talks. She's in the very unleveraged position. And then, that's probably where that's where the settlement usually ends up happening.
That's where you go from there.
And flip it and say that she wins the TRO and the TI hearing, and they cannot keep her from working. Well, the whole time the lawsuit's going on, she's out selling product, doing her whole thing.
Making money.
Yeah. And so it's a lot less enticing at that point for the employer to continue down that path. And so that's why it's important, that discussion of, could they get an injunction? Could they get a restraining order on the front end? Or could you, if you were the employer? That's a conversation you have to have, because really, in my mind, when I'm counseling clients, if the answer is yes or no, that's going to dictate whether I advise you to break it or enforce it or whatever.
Absolutely. Third takeaway?
Third takeaway is that...
Because that was like 2 takeaways right there.
It was 2. Well, yeah, because we wanted to talk about the injunction side, right? Third takeaway would be going back to what actually you're defining your confidential information as. Make sure it's real. Make sure it's tailored. Make sure it's actually things that you are protecting, like you mentioned.
You're actually taking concrete steps to protect, like that client list.
Yeah, absolutely. And those are the big pieces. I think my advice for most employers in this state would be, don't spend your money on non-competes and enforcing non-competes. There's special circumstances where there really is truly confidential information.
Like, for example, chemical product development.
Exactly. Or maybe highly specialized source coding in a technology company. But I always tell them, the money you're going to spend on that, invest it in marketing, just outgun the other employee that's leaving and make more money.
There you go.
It's a better investment than paying us.
Look, everyone's happier if you just go ahead and do that.
Yeah.
Although, I don't know, I like getting paid, so.
I get that, but hey, we've always said we're going to be honest on this show.
We are going to always be honest on this show. We're always honest all the time.
Yeah.
Sometimes I'm just nicer about it than others. But anyway, y'all, thank you so much for listening to our expose on non-competes. But stay tuned for closing arguments. We make a reference to Ginny and Georgia, the new Netflix phenomenon, and Taylor Swift. Holla.
I bet you can guess who's doing this closing argument.
What?
Guys, thanks for listening. Closing arguments are coming up, but make sure before you go rate, review, and subscribe to our podcast anywhere that you listen to your podcast. Check us out on YouTube, and you can check us out on Instagram and talk to us. Tell us what you want to hear about. You can search us at #lawyered, spelled out. You can talk to Andrea at andrea.s.turner, and you can talk to me at the Dallas Lawyer. See y'all again soon.
Hey y'all, welcome back to Closing Arguments. Okay, so if you haven't watched Ginny and Georgia on Netflix, I just binged it last night with Spencer. Yes, he did watch it with me. Beth's husband Hesper. So cute. You have to watch it. But anyway, little Ginny made a sexist remark about Taylor Swift, allegedly saying, "Mom, you go through more boyfriends than Taylor Swift does." T Swift complained, "Oh, that's a sexist comment." Can she have any legal recourse? First of all, no, because Ginny's fictional. And second of all, because Taylor Swift is a public figure, Ginny didn't make that statement with malice. She was just mad at Mama Georgia. So sorry, T Swift, out of luck. Catch you next time.